Bon dia. Benvinguts a tots a aquesta 21a lliçó d'Economia. Vull, en primer lloc, excusar el rector, que es troba una mica lluny fent visita als països llatinoamericans. On behalf of the rector, I would like to apologize for his absence in this very important event today. And I also want to thank Sir John Vickers for accepting our invitation to give the annual opening lecture. This is, as I said, the 21st edition of this Lliçó d'Economia, an event that has become a tradition in the short but quite intensive life of our university. I would like to give the floor to Albert Carreras, which is our dean. Albert.
Thank you very much. It's for us always a pleasure, the moment of the Lliçó d'Economia, and allow me, John, to have some words in Catalan to the constituency. És la 21a, com ha insistit la doctora García Milà, la nostra vicerectora, i és una tradició que hem aconseguit mantenir de manera seguida, que en uns dels primers dies del nou curs convidem a un professora molt distingit que tracta d'un tema d'interès general que poden seguir o poden fer un esforç de seguir tant els estudiants que comencen els estudis com aquells professors que també ens acompanyen durant la presentació. És, per tant, una ocasió de centrar la comunitat i de fixar l'atenció de la comunitat sobre temes d'interès general. La presència del professor John Vickers, que és un gran especialista en política de competència i de regulació, és per nosaltres un gran honor i és, per altra banda, un recordatori d'un dels temes centrals de l'activitat docent de la facultat i de l'activitat investigadora del Departament d'Economia. El presentarà amb més detall el nostre professor més abocat sobre aquests mateixos temes, que és Massimo Motta.
Thank you very much, Albert. It is really a pleasure to have John Vickers here today. John is really one of the most distinguished economic researchers, and it is a pleasure for me to spend a couple of minutes to present John and his work. So, in general, I like to read the CV of people and to try and understand a little bit more about them. So when Albert asked me to present John, I downloaded his CV, and I was also looking for some personal information, such as age, etc. I couldn't find it. But I thought, in general, you can infer from the CV quite a lot of information about people. So I looked at the CV, trying to understand what could be his age. I have known him for quite some time, but still I do not know what his age is. And what I found is that he has about 100 research publications, including several books. He has a number of academic distinctions. So he's a fellow of the Econometric Society, a fellow of the British Academy, a fellow of the European Economic Association. He has been president of the Royal Economic Society. He has already received a doctorate honoris causa by a British university. Then I learned that he has been named professor of political economy at the University of Oxford in 1991. Now, normally I think one becomes professor at Oxford about 50, so that starts to give me some ideas about his age. And then he has been elected the warden of All Souls College, which is one of the most prestigious colleges in Oxford, in 2008. Warden is the equivalent of our rector. He has also held important appointments in public institutions. He has been the chief economist of the Bank of England, and he has been director general and chairman of the Office of Fair Trading, and now is the chairman of the Independent Commission on Banking. And finally, just by this quick look, he has been knighted in 2005. So if we are talking about which age to infer, I think that John must be about 75 years old. And for sure, he has no other interest than economics, and certainly no family. Otherwise, you cannot explain the quality and quantity of his publications and all the appointments that he held. Or there is another explanation. One of the things that I did for fun was also to read some of the newspaper articles which have appeared with interviews, etc., especially since he has been nominated chairman of the Independent Commission on Banking. And one of the newspaper articles says that he has a brain the size of a planet. So maybe that's the possible explanation. So, less jokingly, I will tell you a couple of things more about John's CV. So he was educated at Oriel College in Oxford, and then after his undergraduate studies, he took a summer job working on a very important antitrust case which involved IBM, which I believe it was the start of his long interest in antitrust issues, and which I think he will tell us a little bit also later on during the lecture. Then he worked for Shell for a couple of years, and then he went back to Oxford to finish his studies, and he did most of his academic career in Oxford until he became professor of political economy, as I said before, in 1991. And then is Warden of All Souls, as I said, since 2008. One characteristic of John's CV is this mixture of academic appointments and policy appointments, apart from his spell at IBM and Shell. And indeed, it's remarkable that he was chief economist of the Bank of England and a member of the Monetary Policy Committee, which is the one which decides the monetary policy and the interest rates of the Bank of England between 1998 and 2000. Then he was the Director General and Chairman of the Office of Fair Trading. Now, the Office of Fair Trading is a fairly old institution, but he was nominated at the time in which the Office of Fair Trading became the enforcer of a much tougher law on competition. And so basically he was charged with the responsibility of enforcing for the first time completely different law in line with European law. Before it wasn't like this in the UK. And to set up the organization, to refound a little bit the organization. And I think it has achieved quite a lot in the sense that first, by now, the Office of Fair Trading is possibly the most respected agency in the world, and part of the merit goes to John. And also I think he has another merit, that is that since the first decisions, the Office of Fair Trade under his guide showed a lot of good foundations, both in law and economics, in the decisions that they took. So the Office of Fair Trading basically had an effects-based approach from the very first minute the law was enforced, but at the same time there was this attention to the legal aspects and to the importance of the law and legal certainty, which characterizes most of John's work and these papers on the topic. Now, it has also been said that one person who said that he has been so active and productive at the Office of Fair Trading that when he left the OFT, instead of having one person with one post only, they had to create two posts and have two persons to replace him. And so now there is not a single figure leading the OFT, but there is a chairman and there is chief executive officer. And the person who said that is John Fingleton, who is now the chief executive officer of the Office of Fair Trading, so it must be true. As I said, in June 2010, he became chair of the Independent Commission on Banking, which was established by the UK government to suggest possible reforms of the banking system in the UK in the light of the crisis of the last years. So among the other things, the Commission will have to make proposals as to whether it is desirable, for instance, to split retail banking from investment banking, or it is desirable to take steps so that firms, so that banks do not become too big to fail, which has some clear moral hazard distortions. Now, from the research point of view, he has worked on a number of topics, and most of his articles are very widely cited and extremely influential. He has worked on regulation, he has worked on privatization, and he has 2 books on these 2 topics, which are probably the most important on the topics. Then he has worked on patent races and innovation and its effects on growth, and we are going to listen to some of these in his presentation today. He has worked on vertical relationships and delegation and the theory of the firm, and on price discrimination and bundling, and on consumer search and consumer policy, which is some of his recent work. Now, I've already said of his productivity, both in quality and quantity. Now, when he told me that he was going back to academia after more than 7 years in the Bank of England and in the Office of Trading, I didn't say anything, but I thought he would have a very hard time in being as productive as before. Well, it turns out that I had perfect foresight, like most economists. In the last 2 years, he has published in the American Economic Review, in the Review of Economic Studies, in Econometrica, in the RAND Journal of Economics, in the Journal of the European Economic Association, in the Economic Journal, which is more than most of us publish during all their life. Okay, more than singling out some particular paper of his, I would like to stress what I would regard as a unique feature in his CV and in his profile, which is his ability to do first-rate theory work and at the same time to use it to guide policy on particular topics. And I think that this interaction between theory and practice, between some fundamental theory work and applications of the insights which come from his research, which makes his work really unique. Today, I think we are going to have an example of this. He will tell us what economic research at the frontier has to say on one particular topic, which is competition law in its dealing with property rights. And so his suggestions about how laws should be written and how should be implemented and enforced is always very timely and important. I hope that this interest in both economic theory and applications is something that students will retain and which will help as an example for them in the years to come. Thank you.
So, first let me say thank you very much indeed for the honour of giving this lecture, which I'm really thrilled to do, not least because this is such a distinguished university, both in general and particularly in economics. I must also thank Massimo for those remarks. They prove that you should not always believe what Massimo says. For example, one of many, I mean, he and his family had lunch with me and my family about 2 years ago. So either he has a very bad memory or you should be very skeptical. Now, you see here the topic I want to talk about. It's going to be a talk about the relationship between law and economics. I think it's true that in economics in the last decade or so, more attention has been paid to questions of law in all kinds of economics, development economics, right through to the kinds of thing I will talk about. And I think that's highly desirable. I think there are lots of questions that are both very, very interesting and very important where law and economics meet. And in the United States, there's been a tradition of people thinking about law and economics together. It's often associated with the University of Chicago, but it goes much wider and deeper than that. But I think we in Europe have maybe not been thinking quite so much about these questions. And as I say, I think there are some excellent topics here. And in particular, I will talk about some relationships between two kinds of law that are fundamental to how a market economy operates. The law about property rights, both physical property rights and intellectual property rights. That means patents, copyrights, and so on. So there's all that law, property right law, including intellectual property law. And then we have competition law, which these are two sets of rules of how the market operates. And in most markets, most of the time, they work together very well. The fundamental goals of the market system, economic goals and other goals, are supported by these two pillars. But there are some markets on some occasions where there is a tension, possibly even a conflict, between principles of competition law or competition policy and principles from property rights law. And in the last few years, just in the last decade, there have been a lot of law cases taken to the very highest courts which have concerned these issues, and that's what I want to talk about today. My remarks are based on paper that came out in the Economic Journal a few months ago, and some of the more technical aspects, if you're interested, it's best if you look there than for me to try to explain it in these remarks. But I want to talk today also about two very recent cases which are not mentioned in that paper, because even though it's a recent paper, these two cases are subsequent to it. So the central question I want to take is this one. When, if ever, should competition law require a firm with market power, a dominant firm, to share its property with its rivals? Now, if you are a property law purist, you might say never. Property right law should never be trumped, overcome by competition law. That would be a purist view. But as we'll see, particularly in Europe, there have been some cases, including the very important recent Microsoft case, where a very high court decided that Microsoft had a duty under competition law to share with its rivals intellectual property relating to software in that case, and I'll talk about the case later. At the same time, we've had a lot of cases about access to physical property, not just intellectual property cases, physical property. In particular, a number of recent cases about, take a dominant telecommunications company like British Telecom in my country, but we'll see there have been cases in a lot of the major European countries, where rivals to the dominant firm have said we have a right to access to particularly the local network of that dominant firm. And there have been arguments about whether competition law requires the dominant firm to share that physical property with the rivals, or in particular whether not sharing it is a breach of the law by the dominant firm. So I'll say something about the physical infrastructure cases. Telecommunications will be the main example, and intellectual property, talking about software. And the first question is, should there ever be a duty on a dominant firm in the kind of situation I described to share its property with rivals? And if you answer that with a yes, the next question is, okay, then on what terms, at what levels of price, for example, should the dominant firm have to share that property? So say I'm the dominant firm throughout this lecture, that'll be me and your potential rivals. If the court says I have a duty to share my property with you, but I can set the price at, near infinity, so to say, then, of course, for practical purposes, that would not be effective. So anyone who answers the question, yes, there is a duty to supply, is really obliged to move on to say, okay, but then what principles, rules must the prices satisfy? Now, a second reason to be interested in these questions is that the answer that the courts in the United States have given are very different from the answers that the courts in Europe have given. So there's a big difference across the Atlantic, as I will illustrate. And these are in cases, I'll show you cases in the last 2 or 3 years. This is, recent stuff. I'm not going back into past decades. And just to illustrate this transatlantic difference, I won't read this out, but there's a case called Trinco, which is about access to telecommunications networks. I'll describe the factual background in a little while, but just focus on this paragraph from the Supreme Court. I think being on the US Supreme Court must be one of the most fantastic jobs in the world, because there are 9, as you may know, 9 justices. They're there for life or until they retire, and they interpret what the US Constitution means, what the federal law means, and so on. And all the lower courts have to obey. All the lower courts have to act consistently with the Supreme Court. So this Trinco case was about a principle about, on this question of, is there a duty to share property? And the Supreme Court basically said, at least on the facts of that case, no. And it's a kind of resounding no. And they pointed out 3 evils or 3 risks if you give the other answer, if you say, yes, there is a duty to share property. First of all is an incentive point. If you, the rivals, can have access to my property, my infrastructure, my telecom network, let's say, that may reduce my incentive to invest in that infrastructure and reduce your incentive to invest in a rival infrastructure. That's the incentive argument. Secondly, they say if the court was to say, yes, there is a duty under competition law, the Americans call it antitrust law, then soon the courts would have to be sort of regulators. The courts would act as central planners. It sounds kind of Soviet, So the tone of this is quite strong. And then thirdly, they're worried that if you do have a right to my property, if we then have to negotiate over the price, that may lead slippery slope into us colluding, which is the supreme evil of antitrust law. Okay, so this is quite strong language. Here is some typical European language. This is not a court. This is taken from the first major European Commission case from the early 90s. Not telecommunications, but a very simple thing of whether the operator of a port this is a port in Wales, had to allow access to the port facilities to rival shipping companies. And the Commission said, yes, you do, under competition law. If you're a dominant firm, I'm the dominant firm, let's say, I mustn't discriminate against you in terms of access to this facility. If it's an essential facility, one that you need for your business, then I have to give you access to it under competition law, and I must not give you access on less favorable terms than I'm effectively giving to my own use of it. This was a ports case. There have been lots of other kinds of physical infrastructure, and the telecommunications cases I will talk about. And in the telecommunications cases, the high-level courts in Europe, the courts in Luxembourg, European Community Courts, have been consistent with this. So there's huge difference between the US courts and the European courts. So the talk is going to be in two main parts from now on. I'm going to talk about these physical infrastructure cases, network access, and then the second part will be about competition policy and innovation. So if you want to think about the economics, there's going to be more about dynamics, or at least underlying what I say, there will be more about dynamics when we come on to the second part on innovation. Let's begin with the telecommunications cases. There have been lots of cases very recently. It turns out one of the most important and one of the earliest from the mid-90s is a New Zealand case. And that's of interest to us as economists because the economists William Baumol and Bobby Willig urged on the court, and this bizarrely, for reasons to do with the history of the British Empire, ended up in London, with the House of Lords in London giving judgment on a New Zealand case. And Baumol and Willig effectively persuaded the court, these law lords, that a principle which I'll describe, that they call the efficient component pricing rule, was a good way, a good benchmark for thinking about how the law should apply to these questions. We've then had these American cases, Trinco I just mentioned, and there's one from last year called Link Line, which I'll say a bit about. And then in Europe, we've had SC is Supreme Court, those are the American ones. In Europe, CFI stands for the Court of First Instance. It's not the very highest court in the European community, it's the one below. The very highest is the European Court of Justice. So we've had Deutsche Telekom, France Telecom, and then the Telefonica is a case that I think has not gone to the Luxembourg courts, but was a decision by the European Commission in Brussels, very much in this area. Maybe people here, I'm sure people here know more about Telefonica case than I do. And the kinds of issues are, is there this duty that the dominant firm has under competition law to share property with rivals? If so, how should that be priced? Maybe there are questions about the level of the price at which you have access to my property. Maybe it's not so much the level, but it's if I'm a dominant firm, say I've got a network, and I'm competing with you in a retail activity, or some vertically related activity, maybe the thing is not so much the level of the price I charge you, but whether I squeeze you in terms of the difference between my retail price and the access or wholesale price that I give, at which I give you access. I'll do a toy model of that in just a moment. And in some of these cases, there have been questions about predatory pricing. And predatory pricing is where a dominant firm prices below cost to drive a rival out of a market, or to keep a rival down to small size, or maybe to discourage other rivals from coming into the market. So lots of recent cases, different parts of the world, very similar issues. I talked about price squeeze. This is the only, well, it's too simple to count as a model, so I call it a toy model. And it's the only model I'm going to talk about in this talk, but there are other analytical bits of the Economic Journal paper. So this is to try and sharpen the question. Suppose I'm a dominant firm, vertically integrated, so I'm a pure monopolist over some network. So in telecommunications, that might be the local network. It might be a natural monopoly even. And you and I are competing to supply retail services to final consumers. You might be a long-distance operator, and there were cases in the 70s and 80s about that, or more recently, you might be providing some services over broadband, and access to my local network may be vital for your competitive success. Now, the simplest of all dominant firm models is one where you, all you collectively, are a kind of passive little fringe of firms that take as given the prices dictated by me, and then if you can be profitable at those prices, you'll supply up to the point that you make profits, or maybe I squeeze you out altogether. So let's make it really simple. Suppose it's fixed coefficients, so one final consumption unit needs the combination of one network unit of access and one unit of other services, fixed coefficients. Suppose it's homogeneous goods, you're supplying the same final product as me. Let P stand for the retail price that consumers face. Let A stand for the access price, the price per unit, I'm assuming linear pricing, price per unit that I charge you for using my monopoly network, and define M as the difference between the two. So M is the margin that you can make to cover your retail costs. Let S of M be an upward sloping fringe supply curve. And final simplifying assumption, assume I have a constant marginal cost in the retail activity of C, but suppose that at least up to some scale you're more efficient than me. So some of you, as it were, are more efficient than I am in the retail activity, but you've got capacity constraints. Now, if I'm unconstrained, what will I do? If there's no regulation on me, well, given all the assumptions I've said, my total profit is equal to the profit I would get as a pure monopolist plus this term you see near the bottom, phi of M. It's as though I can make some extra profit from the way I supply you access. Why is that the correct formula? Well, on each unit of access that I supply to you, so you're supplying final consumers in relation to that bit of demand, I save my retail marginal cost of C. So that's a gain to me, but I lose the margin I would have made if I had served those consumers instead of you. So per unit that I supply to you, I make this profit of C minus M, this thing here, multiplied by S, the number of units. Now, just by looking at that, you can see that my most profitable strategy, given all the assumptions I've said, is to squeeze you somewhat relative to what would be efficient. The social optimum for productive efficiency would be M equals C, but I can make more profit, I can get this phi thing to be positive if I squeeze that margin down a bit. So some of you may have heard of the Chicago view that there's only one monopoly profit. This model is, that's not true in this model. I can make additional profit by squeezing you in this way. Now, that's partly to do with my assumption of linear pricing, but I don't want to dwell on that now. So the point I would draw from that is two, really. There may well be a private incentive for me, the monopolist, dominant firm, at least in a very, very simple setting like this, to engage in a price squeeze. Second point is that's inefficient. The social optimum would have me not doing that price squeeze. I would have that margin in line with unit cost. So, the efficient component pricing rule. This is advanced by Baumol, Willig, and others. And they said to the court in this New Zealand case that so long as the price at which I supply access to the network to you, so long as it satisfies the no margin squeeze principle, then it should not count as a breach of competition law for me to set the access price in those ways. So I might be charging you a lot for access, but if my retail price is sufficiently higher so that the difference is at least as great as my marginal cost of the downstream activity, then Baumol and Willig would say that should be considered lawful, not illegal. That should be fine. And the House of Lords in the New Zealand case agreed with that principle. Now, a big attack came on that point from people who said, but look, that's crazy, because on the Baumol-Willig principle, nothing is done to bring the levels of prices down. Their principle is all about a difference between a retail price and a wholesale price. Surely, people said, competition is about pushing down the level of prices. And this rule, this principle, does nothing to bring down the level of prices. Now, the House of Lords, the judges in that case, were well aware of that. And effectively, they said, sure, that's exactly right. But if you look at the other bit of the New Zealand Act, the New Zealand law that the case was about, they said another bit of that law says that the regulator can directly regulate the level of prices. And they said, we've had no evidence that prices are excessive. I mean, probably they were, I don't know, but that hadn't been, there wasn't a mountain of facts to that. So they said it hasn't been proved, and if it's true, the same New Zealand law could allow the regulator to push down on prices. So that was another reason why they did not go further than the Baumol-Willig efficient component pricing rule. So in this judgment is also a point about the relationship between competition law and regulation law. What about the European courts? In this Deutsche Telekom case, something like the efficient component pricing rule has been adopted by the court in Luxembourg. Something like it. And they have used the principle, which I quite like, actually, of the equally efficient competitor. Because if I'm doing a margin squeeze against you, then even though you're more efficient than me for serving some of the business, you don't serve it because I've done this price squeeze. And so there's a natural link between the margin squeeze test, the efficient component pricing rule, and the notion of an equally efficient competitor. But what the European courts are doing is not quite the same, because I think it's, I don't know what Massimo thinks, but my reading of most of the cases is that they would not just apply the test on the basis of marginal costs, which was what mattered in my mini toy model, but they would look at some fixed costs as well. So the European courts are requiring a more generous margin, more room for you to compete with me than the Baumol-Willig style efficient component pricing rule. There is another twist to the Deutsche Telekom case, which brings in regulation. Deutsche Telekom has said, but look, we went to our German telecommunications regulator, and they said our prices were fine. They were authorized by our national regulator. So you, the European courts, can't be, it's just not fair to tell us that we've broken European competition law when our national regulator approved these prices and said these were the prices we had to charge. To which the European Commission and the European Court says, you know, this is the European Union. That is merely a national regulator. We are applying European law across the community. European law is paramount. You could have influenced, you could have proposed different charges to your German regulator. So, no, we don't allow your point. And Deutsche Telekom has appealed now to the very highest court, European Court of Justice, on this question, in particular whether it's a defense that their national regulator approved their charges. Now, a little bit more about these American cases, and you'll see how different they have been, has been the treatment of them. So, Trinco. You might think, what sort of company is Trinco? You've probably never heard of it, unless you happen to know this case. Well, Trinco is actually a lawyer. He's called Curtis V. Trinco, and he runs a law firm. He has his own law firm. And he was a customer of AT&T. And he said that was enough to allow him to sue Verizon, which in New York was the dominant local network operator, because they were not supplying to AT&T, he said, access to that local network on fair terms. So he said it's a breach of US antitrust law. And if in US case, if you're a private plaintiff, most US cases are not brought by the government, they're brought by private firms and individuals. If you win, you get your damages multiplied by 3. So he would have won a big pot of money if he had succeeded, but he did not. He said, look, the 1996 American Telecommunications Act says that the dominant provider, under that regulation law, must supply access. He claimed that the facts were such that Verizon was failing to do that. So he said it's a breach of antitrust law. I win, I get my big pot of money. That's the sort of argument. The Supreme Court said no. They said, of course, there's a regulatory duty to supply on fair terms, but that doesn't mean that there is also a duty under antitrust law, competition law. It's a different kind of law. Now, for Trinco, he needed to win under antitrust law to get the pot of money. So the question for the court was, even let's assume, because such grand courts don't look at facts, they just assume facts. They're like economists, that way, assume what the facts are. Just let's assume these facts. In principle, could it be a breach of antitrust law? Now, you might think, well, if the industry is regulated, that's all the more reason why competition law should apply. Because the fact it's regulated shows you've got a firm with market power. The legislature has moved in this regulatory apparatus, so there's all the more reason to worry about monopoly power. On the other side, you might say, no, if you've got a regulator there, then you should not let antitrust in as well. That would duplicate. It's much better to leave it to the regulator. And that is what, that's one of the strands of argument in this case. So what the outcome was that the court said that the alleged breach of the regulation law does not result in a claim under Section 2 of the Sherman Act. That means the bit of US law about what monopolists can't do. And he said, since there isn't an antitrust law duty to deal with a rival, then there can be no question about the terms of access being unfair. If I don't have to supply you at all under antitrust law, then the court said you can't complain about the price or quality I offer if I do supply you. It's an important distinction, this, about antitrust law or regulation law. So the court said, in fact, if you cannot infer a competition law duty from a regulation duty. Go away, Mr. Trinco. Now, that's what 6 of the 9 justices said. 3 of them said Trinco doesn't have a sufficient interest in telecommunications for us to hear his case. He should just go away. That he's too remote, this law firm, just being a customer of a telecommunications firm. That's not enough. Now, all these things I'm saying about judgments, I'm painting with a very broad brush. There are a lot of subtleties. The precise legal language is very important. But I'm just trying to give you what I think of as the essence of these cases. Move on to the more recent US case of Linkline. This was about internet service providers. I should have mentioned, why are there so many telecommunications cases? It's partly because of the internet and broadband, so the importance commercially of these issues has got much bigger. And in Europe, but not in the United States, it's because a lot of these firms, like Deutsche Telekom, France Telecom, British Telecom, not long ago were state-owned monopolists. So we're emerging in Europe from sort of privatization and deregulation. So in this Linkline case, because of time I won't go into all the detail, you had a similar outcome to the Trinco case, which is that the court said that the Linkline, who was complaining it was being price squeezed, did not have a case because there wasn't an antitrust duty to deal. And 5 of the justices said this. That's their bottom line. 4 of them didn't want to go that far, but they still thought the right outcome was that Linkline should lose. So led by Stephen Breyer, who's a very good economist as well as being a justice of the Supreme Court, he said when a regulatory structure exists, the costs of antitrust enforcement are likely to exceed the benefits. So this shows us another difference between the US and Europe. In Europe, we've been very keen to get competition law into these regulated industries. In the United States, the Supreme Court is in a way trying to keep antitrust out of the regulated industries. It says, you've got a regulator there, he, she can do the job better. I'll skip this. So we've got this really big transatlantic difference about who's winning these cases. One side wins in Europe, roughly. The other side wins in the US. We've got also this quite different view about the relationship between competition law and regulation law. In Europe, we want to get competition law effective in these industries, then maybe we can start deregulating, taking away some of the regulation law, whereas in the US, the court is nervous about antitrust law going into these industries. Now, there are differences across the Atlantic, obviously. One is the facts about these industries. State-owned monopoly not long ago in Europe, not state-owned monopolies in the US. So it's different facts in those terms. And also the law operates differently. In the US, it all happens in the courts, and most cases, except for some mergers, are brought by private parties. In Europe, it's administrative authorities like the European Commission in Brussels, the Spanish Competition Authority, the Office of Fair Trading in the UK. So it's quite different circumstances, and maybe that goes quite a long way to explaining why the law is giving different answers in those 2 jurisdictions. So that's the first block. Second block, I will be briefer, and I want to turn to questions about competition policy and innovation. I want to talk just briefly about allude to some theory, just point you to some lines of theoretical work, and then talk about the European IBM case, which Massimo mentioned, and also this huge recent Microsoft case. Now, given how important these industries and questions are, I think it's in a way quite amazing that this quotation, I think, is completely true. Paper by Ilya Siegel and Mike Winston, which is the effects of antitrust policy, competition policy, on innovation are poorly understood. I think there are a lot of wide open research questions in this area. What can we say? First remark that's important to clear the ground is when we speak of intellectual property, that's different from physical property in all sorts of important economic ways. Not just that physical property is physical, but intellectual property is you can't touch it. That's an obvious difference. It's more that with physical property, there is rivalry in consumption. If you eat my cake, I can't eat it. On the other hand, if intellectual property, if you use my software, I can still use my software. So there are a lot of very important economic differences, and there are some big debates in law about how far one should apply intuitions and principles about physical property, like land and buildings, into the arena of intellectual property. What does the economic theory literature say? Well, when I was by the way, I'm 52. Let's get that sorted out. When I was a graduate student, and that was in the early 80s, that was a good time to be looking at some of these game theory type models of R&D. A lot of them were one-shot models where, say, Massimo and I, we're rivals for a single prize. Now, pretty obviously in those models, if you make the prize more valuable, we will work harder. So if you make the intellectual property, if the amount that's protected increases with the value of the prize, in those one-shot models, you get the simple result that stronger property rights means more incentive to innovate. But more recently, people have been looking at sequential models, where there's not just one round of innovation. There may be round after round. Maybe there's a primary innovation, and then there's competition for improvements or add-on or follow-on innovations. And there, it's not obvious which way it goes. If you strengthen the intellectual property rights, say I've made a primary innovation, and Massimo and I, maybe you as well, competing to make follow-on innovations, the more you strengthen my rights over the primary innovation, maybe that's bad for follow-on innovation rather than good for follow-on innovation. So I think opening up around now, there's some quite interesting ambiguities in how the strength of intellectual property rights might be good or bad for innovation. I think there's quite a lot of reason to think that the law grants intellectual property rights too generously. There's a big debate about intellectual property law itself. I'm going to stick to this question about how competition law relates to intellectual property law. One paper I recommend on this follow-on innovations is Besson and Maskin in the RAND Journal, I think 2009, possibly even 2010. Quite a recent paper. And Maskin, of course, mega famous Nobel laureate. Besson is one of these people who is very skeptical about the strength of intellectual property law. And he's somebody who thinks that you might well get more innovation with weaker intellectual property law rather than the conventional wisdom, which is the other way around. There's lots more I could say about the theory, and there's a passage in the paper which lays out a model, but I don't have the time now to do that. So I'll finish talking about some cases. Begin with a tale of two cases. Massimo, in his opening remarks, correctly, it was the one thing was correct in what he said, was in about 1980, when I was a little bunny economist, my main economics professor was consulting for IBM on an investigation that the European Commission was doing into an alleged abuse of a dominant position by IBM, which was then the most powerful computer company by a long, long way. There had been a case in the United States which started in 1969 on the last day of the presidency of Lyndon Johnson. And this case went on 13 years, spanning 5 US presidencies, before the US dropped the case under the Reagan administration in 1982. And the European Commission in the late 70s, I think, started looking at this and stated its case against IBM, not a decision against IBM, but what's called a statement of objections in 1980. And the following year, 1981, I worked for about 6 months on the case. And one of the core issues was an allegation that IBM had a competition law duty to tell its rivals how all the computer interfaces worked. So the rivals who wanted to make hardware products, like there were things like disk drives and other peripheral devices. They're all now boxed in, you know, a tiny little thing like this, but you had all these wires and everything then. People making software products and so on. Those rivals said IBM should tell us how all the interfaces work, because otherwise we can't make these products in time. They should give us early information about all that. IBM said, no, 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 those interfaces, they're part of the innovation. Those are our intellectual property rights. There is no competition law duty to tell you how all those things work. There were some other issues in the case as well. Now, all those things came up again in the Microsoft case about 20-something years later. Microsoft was then the major worldwide computer company. The US government had run a case in the late 90s. Again, it was about standards. In the 70s, it was about the IBM System 370 architecture. With Microsoft, it was about the Windows operating system. But all these facts were true in those 2 cases, which are a generation apart. I was not involved in it in any way in the Microsoft case. So the outcome of this IBM case was actually no decision, but a settlement. So IBM settled the case in 1984, and they undertook, they said, we haven't broken the law, we're not accepting that at all, we deny it, but to settle the case, to make the issue go away, we will disclose this interface information to rivals, I forget within how many months, but there was some time scale. They had to do that for all their new products. And this might seem quite amusing now. They said, okay, we agree to unbundle computers without the main memory. So they said, we'll offer our big mainframe computers, which are the size of, you know, that desk. We'll agree to supply it without a memory. Now we have memories in, you know, in your phone, but there, IBM, this is only, you know, 25, 30 years ago, was agreed to do that unbundling. Now, my little bunny economist on the case, I had to try and help come up with arguments that IBM was not a dominant firm. And given its market position in the 70s, that was not the easiest proposition to sustain. It is, however, remarkable how quickly, you know, if you fast forward to 1990, the market position of IBM, because the crown jewels was really the software, not the hardware, and Microsoft very rapidly became the, I try to avoid the word, the preeminent global computer company. Now, some people think that the baton is going to pass to Google. I mean, who knows? But some of the arguments that I was involved with in about 1981 looked a lot better with the facts as they were shortly after. I mean, it was a rather good prediction in some ways. Because IBM's case was, okay, we've got quite a big market share, but the future is not these big mainframes. The future is going to be distributed processing. Personal computers hadn't been invented. We had prototypes in the office that weren't even on the market at that time. It's going to be distributed networking and so on. And that all happened. And the key thing then became the software and Microsoft position. So what happened between these 2 cases, between the IBM case and the Microsoft case of this decade? Well, in the very unlikely area of television listing magazines, those magazines that tell you what's going to be on television next week. There was a European case, which was the first case, it's called McGill, where the European Court agreed with the European Commission that the owner of copyrights, so broadcasters like the BBC, they know, they've got a list of next week's programs, that they wouldn't let this guy McGill publish those in his magazine. He's an Irish guy, he wanted to do this. They said, no, it's copyright, that's intellectual property, you can't have that. But the court said, yes, under some very, very special circumstances, you have a competition law duty to do that. And that opened the door to competition law having preeminence in exceptional circumstances over intellectual property law. Some people, especially Americans, were horrified that should happen. But that was the opening of the door, which went a little bit further, in this case, IMS Health, which was about the geographical map for distributing pharmaceuticals. And it's kind of amazing that should be covered by intellectual property, but and I think that may have been disputed, but I think for the purpose of that case, it was assumed that it did. So these were kind of odd cases. You know, the BBC's listings of its programs next week sounds very different from Microsoft software. I mean, one seems a lot more innovative than the other. These TV listings is just a byproduct of being a broadcaster, whereas for Microsoft, that software is the essence of what it does. But these cases shows how the law works. These cases were a huge deal when it got to the Microsoft case in Europe. I'm just going to give you the timeline of this case and jump to the bottom line, and then I'll wrap up. So in March 2004, the Commission decided that Microsoft had abused its dominant position by refusing to supply interoperability information, like the IBM interface information, to its rivals. And also a second, completely different bit of the case was about bundling the media player software with Windows. Microsoft appealed. Microsoft said, look, take those principles that the court has set down in cases like McGill, and we obviously win. The Commission said, no, you've got to look at the big picture, you've got to look at the big picture. And anyway, the result was that the Commission won and Microsoft lost, and big time. So the court's reasoning, which I personally had no involvement in the case. I was pleased that Microsoft lost that case, but I did not welcome the ease by which it won, because it seems now to open the possibility that it's quite easy for a rival, or maybe quite easy for a rival, to get access to the intellectual property of dominant firms. And I'm nervous that that's too easy and that it may have these bad incentive effects. There was another more recent Microsoft case that was settled, but now the IBM case is back. And actually, IBM lawyers got back in touch with me a few months ago, and I'm doing a very small amount of work for IBM in this new investigation. No decisions or anything, but the Commission announced in July that it is looking at complaints made by some rivals to IBM. In a way, mainframes with the internet and servers have, in some sense, come back into being more important than perhaps people appreciated. But I've no idea how the case will develop. The law in Europe, you first have to show that the firm is dominant, and whether or not IBM is dominant in 2010 looks to me a very, very different set of facts from in 1980. So there's a dominance question. The question of abuse you only get onto if it's shown that there is dominance, but it's premature to say any more about that case. So conclusions. I think these are very, very interesting questions. I think they're important. I think economics has a role then playing into these debates. They're getting very different answers on different sides of the Atlantic. On the regulated industry cases, I hope that we in Europe do not follow this US line of keeping competition law out of the regulated industries. I think we should get it into the regulated industries, partly because we can then have less regulation. I recognize the facts are different in Europe compared with America, so that might be part of it. I am a bit concerned about some of the evolving interpretation of the European law of abuse of dominance, that it's become a bit too easy for the complaining firms to win, and also that we have a lack of economic foundation for this bit of European competition law. Other bits, like vertical agreements, like mergers, I think now have a good economics grounding, but this one bit of the law I am less sure about. Final remark on all this is that we as economists should not think of the law as a closed book to us. Economics can have a big influence on which laws parliaments enact, but also experience shows, particularly in the United States, somewhat also in Europe, that economics can influence how law gets interpreted by the courts. But if we economists are to have any impact, we're going to have to understand the law better than many of us do, and also speak in a language that is understandable to the lawyers and ultimately the judges, and not just to our fellow economists. I have a postscript. If you want to talk about American football, there's one more case, but I think I've used my allotted time. And I'll come to that if you'd like me to, but I think I should stop and take questions on what I've said up till now. Thank you. Should I stay here or come?
Wherever you like. It's time for questions. Javier, please. Yeah, we need the mic. Javier, yeah, we need the microphone.
So I'm sure that if you consider intellectual property when you discover protein, and our sponsor is a laboratory, so I'm sure he will agree, then it's clear that you have to protect this intellectual property. But then think of Pythagoras' theorem. I'm very glad it was not protected by intellectual property. So where do you put how do you set the limit between what is a public good that has to be really in the public and a private good like the protein?
I mean, there is a deep economic question about why society uses property rights, which means the right to exclude, as probably the principal motivator of innovation. I mean, there are also business secrets, which are where you can't use it just because you don't know about it. That's another kind of thing. And people like Jean Tirole, I know, are working on that very fundamental question. I have not studied this closely, but my reading of the literature and talking to people like my colleague Paul Klemperer makes me believe that intellectual property rights have been accorded too widely. And I think there have been some legal developments where I think that's regrettable, where I think many of us economists would draw the line less generously than the law has. And there are a lot of questions about the way the patent application, I mean, patents are just one kind. There's also copyright and so on. I think it was extraordinary of the US legislature to extend copyright retrospectively. I mean, they did this some years ago, which was great for the Disney Corporation because Mickey Mouse was about to enter the public domain. And they kept Mickey Mouse and all his friends the property of Disney for longer. So the incentive argument in that case is non-existent because this was retrospective. I mean, it's one thing to say from now on, you get an extra 10 years, but to do it retrospectively, it's not going to change Walt Disney's incentives, not now. So that was, extraordinary. There are also questions about the burden of proof in patent applications. Part of the test is the thing obvious? Now, if I'm a guy in a patent office, Pythagoras, if I was badly educated, then Pythagoras' theorem's not obvious at all. Wow, isn't that amazing, right? So there are problems about the standard of obviousness, and there are also problems about challenging patents, because if Xavier's got a patent and we're competitors, and I take a case against him and I say he doesn't really have a patent that should fail as a patent, if I win, then all of you have access to it as well, so I don't capture the gain of winning. So for all these reasons, I think there's good reason to think it's gone too wide. What I was talking about here, though, is not that question, but the more particular one of when should competition law eat into intellectual property rights? And I think that's much harder, because I think it's consistent to think that intellectual property rights may have, in some types of product or service, gone too wide, and at the same time to think you should be very cautious about letting another type of law eat into those property rights.
More questions? You have one, Massimo?
So, for the physical property, and it can be used also in intellectual property, why don't we split up those companies? For example, one will be the distributor, and the other one the commercializator, and just being a partner, the first firm being a partner of the second ones without collusion.
That's a very good question, and I think in the work I did years ago on privatization and regulation, I often thought in a number of industries that was exactly the right thing to do, because regulating the conduct of firms at this boundary can be incredibly difficult and lots of disputes, and it needs to be regulated and so on. But if the monopolist just stays doing the network stuff and doesn't own any firms operating in the other sector, then there's no anti-competitive incentive to discriminate. There may be other incentives to do discriminatory pricing, but it's not an anti-competitive one. Now, on the other hand, if there are important economies of scale between the two, then you lose those benefits. But often the cleanest solution was to split. Now, in the UK, they did split with electricity, so the generators and the wires companies were separated. Gas, they didn't. It's ironic because it was easier to do the split for gas than electricity in many ways. In the US, they split in 1982, or 84 ultimately. They split telecommunications between local and long distance. But there have been quite a lot of mergers since where the split has somewhat been undone. Another very controversial split in the UK was the railway system, the track operation and the train service provision. It's arguable that there are probably quite a lot of economies of scope, but that one was split. British Telecommunications was not split. Of course, these were often very political decisions too. And the management of these firms, they definitely did not want these things split. And sometimes the politicians said, well, it's going to be split, and sometimes they left it intact. But it's a good question, good point. While you're thinking, shall I do 2 minutes on... Oh, could we go back to my... thank you. The very latest news from the Supreme Court in the United States. I had that quotation at the beginning where they talk about the supreme evil of collusion. So here's a question they had. I don't know how many of you have seen American football. So there's the NFL, National Football League, 32 teams, and they end up playing in the Super Bowl. Now, to run a football league, you clearly have, the teams all have to agree on things like the rules of football. Right. Now, that's not a breach of the antitrust law. That's absolutely fine. But what they did 10 years ago was the 32 teams gave the National Football League, the central entity, the right to grant an exclusive license to produce trademarked headgear, those sort of baseball hats, except it's football, not baseball. And those are trademarks, which is another kind of intellectual property. So one of the firms called American Needle that had been making these hats lost out when this exclusive contract came in. It was shut out. And they brought a case which ended up in the Supreme Court. And the question is it against or could it be against the bit of US antitrust law about collusion for the 32 teams in the league, each to give this contract to the National Football League? Now, the National Football League and all the teams said, well, of course not, because we're one entity. You can't have collusion within a single entity. The other side said, no, you're one entity for setting the rules of football, but you're not one entity for making hats that the fans wear. You're 32 different entities. And the Supreme Court in this recent case agreed for once, the first time in nearly 20 years in an antitrust case, agreed with the plaintiff. In other words, the person bringing the case. And I think you have to go back something like 15 cases in a row. It's been the antitrust defendant that has won case after case after case. So here is one where the Supreme Court's gone the other way on this collusion point. Quite an interesting question, actually. When is it a single firm? When is it separate firms? And it's a good read, this judgment. They're well-written, short judgments that you get from the US Supreme Court, and I recommend them. Right, sorry, more questions.
Yes. We all know that Windows and Google have developed dominant positions in their respective areas. What do you think about the measures taken so far to break, in some extent, these positions, and what will happen in the future?
Do you mean with Google or with both?
Windows and Google.
Both of them, okay. Well, as I indicated, I was pleased that the European Commission won in the Microsoft case that I described, which was about the obligation on Microsoft to disclose this interoperability information. I thought that was the right outcome. What I'm nervous about is how easily in the court judgment the Commission's decision was upheld. In the US Microsoft case, the US government, the case began in the 90s under the Democrat administration. I was pleased they won that case. What was disappointing was the remedies at the end of that case that were negotiated when the Bush administration came in, I think have been very, very weak in terms of their effects. So, again, I've got mixed feelings about how that ended up. Google, I don't know what to think. I mean, it is the most astonishing innovation. I mean, it's transformed how you go about doing research work and all the rest of it. How that will evolve, whether in some indirect way things related to search engines will undermine the power that Microsoft still has, I don't know. I think a very interesting thing to watch is whether there will start to be a line of Google cases from Brussels or from Washington, or private cases from now on. But this is so recent. Also, there was a famous remark by a US judge that said, and I won't do it perfectly, the successful competitor, having been urged to compete, must not be turned against when he wins. So I think some restraint in intervening against successful firms even if they have positions of substantial market power, is probably a good thing. I hope that responds.
We'll take the last question briefly. Thanks.
Don't you think that it's a mistake to think as the intellectual property as one only thing when it refers to many things, like, for example, moral rights, or also it's different to talk about the property rights in intellectual property rights in medicines, which have a social component, or, for example, technology, which, for example, Linux and all these open source things have shown that many people working on the same thing can have other incentives to make a better product like Linux than Windows, for example, which is a big company, one eye on.
Yep. The short answer is yes. I was perhaps speaking about intellectual property as one big lump. I think I said that there are these different, in law, these very different kinds. A patent is very different from a copyright and is very different from a trademark. So for a patent, I have to show that there's been a substantial step, that it's not obvious, and so on. And to get the patent, I have to show the world what I did. Copyright is a completely different kind of law. Trademarks, which is like a certification of origin, a different thing again. And as you pointed out, you've got these different kinds of intellectual property are playing very different roles in very different market settings. So differentiation and subtlety is really important. I mean, as Massimo indicated, I've now got this role involving the Banking Commission inquiry in the UK. If I had not done that, I was going to try and learn properly some intellectual property law, including a number of these subtleties and differences, because I think it goes to this point about how economists can try to make progress in this area. You've got to understand the law to some level. And I think economists in Europe there's a lot of potential for upside in that respect. So I think you're absolutely right, and it's a good note on which to end.
Okay. Before we go, I would like to thank again Professor Vickers for his enlightening conference. I think he explained very well the tension between the competition principles and the property rights, and gave very interesting examples from the two sides of the Atlantic, and also actually reinforce an adventure we have here with the school, which is to have this kind of marriage between law and economics is actually part of our project. So let me just very briefly say that I have the honor to represent today the rector, who, as I said, could not be here today, but especially because this is a very important academic event that takes place every year, and it's the most important for the Facultad de Ciencias Económicas y Empresarials. In fact, students and professors have already been doing their job for a couple of weeks, but anyway, this is like the first big important act to start the academic year. Once again this year, we have confirmed that our degree is one of the most demanded among students that finish high school and lean their interest towards economics. For yet another year, we have the best young people that want to study economic and business, and as professors, we once more have the challenge to be up to their expectations and their capacities. A combination that has been, and I hope it will be for many years, key to success of the model we have at this university. We've been following this model overall, but it's really strong and robust here at this School of Business and Economics and at the Department of Economics. So we've been increasing our recognition internationally, and we keep building upon this model. I would, to finish, I would like to thank the sponsors that are going with us every year and that are today represented by Mr. Miquel from Garrigues Advocats and Mr. Raffles from Esteve. And they actually have been sponsoring not only this academic act, but also they walk along with us in helping us to define a little bit what are the key issues that will be good in our degrees to have successful graduates once they come out to the market. So for all that, thanks again for another year to be here. And I think I have to officially declare the academic year inaugurated. Opening.